Good afternoon. My name is Greg Hill. I'm an attorney here in Florida, and as Carrie may have mentioned, we're going to try and get you out of here early, but they left a lawyer up for last, so I don't know that's necessarily guaranteed. I've been practicing for about the last 15 years here in Florida. Prior to that, I was with the Tampa Police Department for about 10 years. I specialized in child abuse investigations and traffic homicide cases. I've tried everything from petty thefts all the way to death penalty cases here in the state of Florida, to include a speedy trial, co-defendant who flipped halfway through trial in Palm Beach County. So we're going to go through some of the legal considerations that are associated with the FIDO program. We have the secret back room where we were watching you all and listening to your questions for the last hour or so, and have a little bit of advance notice of what you guys are looking for and some of the questions you had and some of the concerns you had. So hopefully we'll be able to address some of those and answer any questions you may have. The nice part about this aspect, and the nice thing that NFSTCD and NIJ does, is provide you a real-life defense attorney that can answer the questions that you have as to why they do something, how they do something, how they provide the strategies, how they build their cases, how they try and embarrass you, how they ask those tough questions and keep you on the stand longer than you need to be. So now is the time to ask, because there's no recross, there's no redirections, there's no embarrassing jury to be in front of, and I'll answer as much as I possibly can throughout. The way we've laid this out, I wouldn't be an attorney if I didn't have a really good legal disclaimer, so you can read that real quick, and that being done, we'll move to the next section, okay? In essence, what that does is basically says, I'm going to give you some generic legal framework to understand how the systems work, and they're pretty uniform across the states, regardless of which jurisdiction you're from. But in order to keep my bar license here in the state of Florida, I like to make sure that everyone understands I'm not providing legal advice. If I were, I'd be sending each of you a separate invoice at a rate much more than you're prepared to pay. So the overview of what we're going to look at, and the first portion we'll probably go through pretty quickly because, again, it's very diverse. I've provided quite a bit of material in the thumb drives that you have. There's some case laws that you have, the statutes, jury instructions, and then what I'd like to spend the bulk of our time on, I'm sure what you probably want to spend the bulk of your time on, is actually doing the courtroom testimony portion. 1970, the federal government, Congress, decided they were going to enact the Drug Abuse Prevention and Control Act. This provided the framework and the structure for what is currently all the drug laws and in each of your states that you're familiar with. All the schedules, all the classifications, the levels, and all of the, whether it's controlled, whether it's not controlled, and it's modified by Congress as we go through. Each of the states that's represented here today has adopted this in one format or another. Each state then alters or makes some modifications to it to tweak it to their particular needs and their legislative scheme. Since states like to be individuals, they all like to have different numbering schemes, different naming schemes, and so just for information's sake, if you want to find out and really research your legal statutes, there's your sources for your respective states. When you couple another portion that's critical here, and what's probably even more so than the drug laws themselves, are the evidence codes. Evidence codes control what comes in, when it comes in, how it comes in, who brings it in, who can testify, who can't testify. Actually, believe it or not, Massachusetts, I could not find Massachusetts evidence code by number. Thank you, sir. Which is why I practice in Florida. I went to law school in New York, up in Buffalo. I thought I missed the seasons after being down here for a number of years. I went there for the first semester and realized I don't miss the seasons. So now if I want to see snow, I turn on the Weather Channel and we go from there. Plus their bar is atrocious. 21 subject matters, no hint as to which of the 21 you'll be tested on, and it's pretty much all essay. Jury instructions. This is just an extract from one of the drug statutes that provides, and it's pretty obvious for the most part, that if you're going to be charged with possession of a drug, one of the elements that state would have to prove is that it was the drug. Very straightforward. What I tell people to think about is, from a defense standpoint, when I get a case, the first thing I do is I go to the jury instructions. I don't even look at the statute to start, because I want to know at the end, what does the jury have to consider? And where do I work backwards? I deconstruct it and go back to the beginning from there. So if you start looking at what you have to prove, or what the state is going to have to prove with you, the elements that you're going to need to produce, it'll give you an idea of some of the things you can do or shouldn't do in terms of preparing your cases and documenting your cases. Standards of admissibility. There's, in the grand scheme of things, there's 3 of them. And we'll refer to them briefly, but we'll go into them a little bit in detail. Daubert, Frye, and the hybrids. Daubert is probably the most liberal of the standards. It gives the court the most leeway in terms of what to consider and what's relevant, what is not relevant. Surprisingly, it's a little bit disconcerting in the fact that a recent study that was in Florida and is repeated nationwide was that only about 5% of judges and lawyers have any kind of scientific background whatsoever. But they're going to decide what's scientifically reliable and what's not. And the lawyers in the room know that we don't do science. We rely on you guys to give us the science so we can present it. We're the stage puppets. We're just there to go through and provide what you guys present for us. It's commonly referred to as gatekeeper. There's 22 states that have adopted that. And those, again, Frye, which is, we'll go into next, is a general acceptance. That's actually one of the standards that the court can consider in terms of whether a piece of evidence is admissible or not. Frye, on the other hand, actually Frye starts from a 1923 case. It was basically the early polygraph physical manifestation of deception, heart rate, systolic blood pressure, things of that nature. And in essence, what Frye decided was that it had not been generally accepted within the community as being reliable, and therefore it wasn't admissible in Frye. But that set the standard of what the courts had to consider. Was the science and what was being proposed generally accepted within the scientific community to be reliable enough to present to a jury without confusing them? The hybrids in Massachusetts, again standing out by themselves, is one of those few. But again, all the hybrids still actually incorporate part of Frye and Daubert into their analysis. They just have taken it that extra step to make it their own personal animal and either create some specialized language, some steps or procedures that they like to use as measures within the courts. What I'd like to do now is go a little bit more. I told you the legal part would be really fast, but I know you guys have a lot of questions, and most people do. One of the things I also do for NFSTC is the mock trial training for their DNA analysts. So it always comes up, well, what happens if I say this, or how do I get qualified here, or how do I do this? And being able to present those issues ahead of time makes it a lot easier when you're on the stand. How many people have been actually accepted as experts within their jurisdictions? Just a handful. How many have not testified as far as the drug testing so far? A couple as well. So we got a good mix. Has anybody never testified who's an officer? One? Okay. You'll have fun. There's always a first time. We all got to start somewhere. So what we'll do is we'll go through a little bit of the qualifications and some of the direct examination issues, but probably most importantly, some of the cross-examination issues. Some of the things that, how do you get beyond this point? How do you answer this question? Do you dare battle with the defense attorney? How do you help the prosecutor? Things like that. So how do you get qualified? Well, the federal rule of evidence, which is adopted by all the states for the most part, or to some degree, basically if it's scientific, technical, or specialized knowledge of some sort that will help a jury understand an issue, and someone is specially trained and qualified to talk about that process or that procedure or that technique, then they'll be allowed to testify as an expert opinion and provide expert opinion. Now, that leads to a kind of a weird situation in terms of law enforcement officers. Are they experts or are they not experts? Where do they cross the line between lay opinion testimony, which they can't testify to expert issues, and when do they have to be qualified? From a very realistic standpoint, and probably from a pure, more legal standpoint, once an officer testifies beyond his normal scope of training, from the defense side, they're probably going to always try and push that it has to be qualified as an expert. Not that they have to be, and as you'll see shortly, it's not required by the courts, it's not required by all the law, but from a pure reading of this statute and the rules that apply, once you get to that level, you should be qualified as an expert. Now, there's pros and cons to being qualified as an expert. But as you'll see, there's nothing that requires them to have to go through that process every single time because they have the training and they'll have the qualifications. Question is whether the prosecutor wants to have them go in or not as an expert. There's a question forming. No? Okay. You looked like you had a question about ready to pop out. Okay. So what I've done is break this down just a little bit. What subject matter is admissible in terms of expert testimony, if it's scientific, technical, or other specialized knowledge. There's no bright, definitive rule, this is or this isn't subject matter that's relevant to expert testimony. There's no definitive rule. It just, if it falls within any of those, then that's admissible under evidence and it's relevant. So then who can present this stuff? Who can come in and talk about it? Do they have to have a PhD? Do they have to have a master's? Do they have to have a bachelor's? Do they have to go through years of training? I mean, do they have to have a minimum number of years of training? What are the standards? And how do you get there? And the rule is just very simple, a qualified witness. There is no requirement that it has to be a police officer or a PhD. The fun part, being qualified. Again, this extracts it from the rule, and I break it down for you to be able to track where you're at individually and what your strengths and your areas of that probably need to be beefed up a little bit. Knowledge, skill, experience, training, and education. And quite simply, everything counts. You go to a seminar, it counts. You come to this training, it counts. You go to training tomorrow, you go to a conference, IACP or NSA conferences, they count. All those meetings, all those conferences that you attend, it doesn't necessarily have to be specifically on the subject matter. Now, it certainly helps if you focus on some of those and become familiar with those materials, but all those trainings enhance your education and your experience. You'll notice that there's no requirement anywhere in the rule that says it has to be knowledge gained through an accredited university. Nothing that says it has to be degree-oriented. Doesn't even have anything that has to be accredited necessarily. Just your base knowledge. If you go read a book or read an article or a published paper about FIDO or any of the drugs or any of the schedules, all that counts in terms of your experience and building your knowledge base. One thing I recommend and suggest highly for everyone is to prepare a CV. Have a CV ready for your prosecutor so he knows where you're at or she knows what you're prepared to testify to and where you can and can't go. In preparing for this section here, one of the things I noticed was that one of the challenges you come across is, well, you're not a toxicologist. You're not a pharmacist. You're not a chemist. But if my client's paying me enough to defend him and assert his rights, and you're going to testify against him and he's possibly going to go to prison or jail for that matter, you know I'm going to ask those questions. But it's not going to be quite as simple. Well, you're not a chemist. No, I'll ask you something more like drawing the chemical structure of some molecule. And then when you say you can't do it, I said, well, but you're an expert. And it's kind of an underhanded way of bringing it out, but it's a way to highlight to a jury that there's limitations as a qualification. Now, there's nothing wrong with that. And that happens with, I have yet to find a person, no matter what degree they do, no matter what profession they're in, that doesn't have those limitations. But those are some of those questions that you can expect to have thrown at you. The early days of DNA, the DNA, when they first started switching over from population geneticists who had to do the statistics, were doing longhand multiplication and formulas on the chalkboard. You know, back in the OJ day, they were getting up doing the actual formulas on the board. You can expect something like that to be thrown out in terms of the drugs that you're testing, the effects, what other things could possibly be presented that manifest those physical manifestations in an individual, absorption rates, how, you know, all those things, you know, how body weight compares to drug absorption and things like that, of that nature. So if you have all these, and I kind of got a little bit off track, but when going in these issues, if you have these things delineated in your CV, your prosecutor will know where you're at and what to be prepared for. He'll also know what issues are involved in this particular case, so he can help you prepare for those questions that may or may not arise. But at least then you're prepared. And it's easier to do that ahead of time than it is while you're sitting on the stand. One of the things I've provided in the thumb drives that you were provided by NFSTC is a case tracking record. And it's just a sample. It's not necessarily required. It's not necessarily part of FIDO in the sense that it's not something that they put out. This is something that you can use for your personal benefit in terms of tracking how many cases you've actually conducted the testing on. One of the things that you'll find, and how many times have you tested? Well, how many times have you tested for cocaine? How many times have you tested for meth? On and on. What were the results? Did you have any false positives? Do you have any proficiency issues? Any quality control issues? If you keep kind of a running log, you'll have that immediately accessible, and where a lot of lawyers will ask the question, not really expect a solid answer, or, well, I don't know, hundreds, thousands, I don't know. If you can give a precise number of those, it just sounds so much more professional, and you know, well, how many times have you tested for marijuana? 753 in a 3-year span. Okay, well, and what it does, it builds your credibility in terms of the detail that you're providing. You're not just doing that hundreds. It just really enhances if you can give a solid number and if you've had any issues with it. And again, this is just kind of a sample that I put out there. It's certainly not definitive in its shape, form, and you can modify it any way you like. Prosecutors, how often do you have time to sit down with your witnesses before you get in these cases? As you're walking in the courtroom? When you have a case that you come up for trial, or if it's coming in to be presented to court, try and get there a little bit early if it's the day of court. If you have a chance, call the day before if you can, just to touch base, say, hey, is there anything else that I need, anything that we have to be concerned with? Just communicate with the prosecutor that's handling your case so that they know where you're at, and if you can start preparing if there's anything they need answers to. I always encourage prosecutors and law enforcement to communicate with each other. You usually do for the most part, but sometimes those things slip through, and next thing you know, you're walking in, well, did you bring that evidence with you, or did you find out about this issue? Because it's just last-second type things that pop up. Since this program and these programs are relatively new, you'll probably find quite a few prosecutors who aren't as familiar with them. FIDO. No idea what that is. A along with the testing capabilities and some of the parameters of what the kits provide. You're going to have to educate your prosecutors what they can and can't do, what you can and can't do, what you can and cannot testify to. Make sure that you understand the capabilities, they understand the capabilities, as well as the limitations. With any scientific testimony, what I normally encourage people to do is follow what I call FIDO. Here's the science. Here's what it is. Here's what it does. Here's what it can do. Here's what it can't do. Period. Next part. Here's my examination. Here's my testing. Here's what I did. And then finally, based on what the science can do, based on what my examination and testing results were, here's my opinion. That framework will eliminate probably at least 50% of your time on the stand. What I find is that people who start exceeding any of those scopes, and it can be called 100 different things. When you start exceeding those scopes or you start exceeding those parameters, you start opening yourself up to attack. You start opening yourself up to the embarrassing question. You'll find yourself on the stand considerably longer. So if you stay strictly within that confine or pretty close to that confine, you'll find that the questions get shorter, they're more direct, and they're a lot easier to get in and out of the stand and provide some efficient testimony. Sir?
Question. I'm in Louisiana and we use Daubert, and I had a recent case of possession with intent to distribute, and had my expert witness on the stand, and he was going to be an expert in narcotics use and packaging. And how far could he go on the line as far as giving his expert opinion without inferring the guilt of the defendant, such that it could get overturned or a mistrial? Because I was drawing a lot of objections from the defense, because he was saying, in this case, and it just seemed to be a fine line from what he looked at in the facts and what his opinion was, and whether it crossed over well. In this case, this guy showed that he was going to distribute because of the packaging and the amount.
Well, as soon as you get to that level, and again, remember the rules are expert opinion testimony is permissible even on the ultimate issue. So it doesn't necessarily preclude it. It's that, does he have a basis for coming to that conclusion? And if you set the predicate for, here's the foundation of, here's how I know this, here's my knowledge base for my expertise for it, here's the application in this particular case, and what these factors are, and here's my opinion based upon those comparisons. Then, again, then you just end up with, depending on your judge, whether he's willing to let that come in or not. And your objections the objections are just more for the record at that point, because it's just a matter of establishing it should or shouldn't have come in.
Yeah.
In fact, speaking of Louisiana, you had asked earlier from the other speaker about when you get your expert, I guess the threshold of when the law enforcement officer has to testify as an expert versus a lay witness.
Right.
And you didn't have any cases that really kind of clarified that. For the non-lawyers, bear with me a second. The lawyers will understand this entirely. State versus Lewis, 654 Southern 2nd, 761. All these are reprinted in your thumb drives in their entirety, but it's a 4th Circuit 1995 case. That, again, it's not exactly on point, but it's close enough to get you some groundwork to start working from there. That was a DNA case that the expert was precluded from testifying at the trial court because she was the associate director who had not conducted the actual testing. She did not have a PhD. She had limited other qualifications, such as she was co-published. She wasn't the primary publisher in some articles. So the defense argued that she wasn't qualified and she didn't do the testing. That court, the appellate court, said that the trial court misapplied Daubert and applied it to the individual qualifications versus the testing, and therefore she should have been allowed to testify. Another one, State versus Kestel, Kestle, 996 Southern 2nd, 275. It's a 2008 Supreme Court case that actually provide clarification when officers' lay opinion testimony in conjunction with other evidence was past sufficiency.
The first citation on Lewis was 654 Southern 2nd, 761.
Yes, sir.
Thanks.
Now, and there's a lot of case law out there, and it's the cases you can look at are for your particular state. What I'd suggest that you look at, though, is look at all the other states that are in there. There's only, there's like 4 or 5 cases, 3 or 4 cases for each state. But since everybody's Fry or everybody's Daubert, sorry, Massachusetts. Since they're, but even Massachusetts, because again, like I said earlier on, they're all kind of mixed together anyhow. What you find may be applicable in Florida will be equally applicable in Louisiana, because again, it's just a crossover. It's a mechanism that the courts have used to kind of set their own ground rules, but they all kind of cross over. So reading other cases are interesting enough. And a lot of them are, like I said, what I try to do is provide some samples from qualifications to DRE testing, whether DRE is acceptable and whether it's going to meet the qualifications as an expert testimony, which again, according to the cases we have so far, they should. So there's no reason a DRE doesn't qualify. In fact, there is some case law that says you don't even have to have chemical or scientific testing to prove a substance is an illegal substance. Questions so far? All right. What I'd like to do here, because I know that everybody's anxious to do these and rehearse some of these things. One of the things I also suggest people do real quick before we jump here is there's certain things that you're going to have to answer every single time you testify. What is FIDO? What does it stand for? How does it work? What kit do you use? What are the chemicals in the kit? What I suggest is that instead of just kind of winging it, formulate your answers ahead of time. There are going to be stock questions. You have to have stock answers. The more efficient you are at those and practice those, the more natural they'll come across, the more efficient you'll be, the more professional will come across to the juror or the judge, whoever the audience may be. And let's face it, if you have the answer already, you don't have to take the time to think of it when you're on the stand. One less thing to worry about while you're trying to come up with the right words. You don't have to stumble over those because they're pretty much stock and they're pretty standard. Who has a response for you're not a chemist or a toxicologist? Who's going to take a stab at it? Who's my most senior law officer here? You look like you're hiding, so we'll come back to you.
I could say I'm not a skydiver either, but I wouldn't jump out of a plane. I mean, one thing obviously is you don't need a degree to make a determination of something. You just said that. So.
Mm-hmm. Well, I've said that, and you know that, but how are you going to let the jury know that? Any other, help them out.
How about if you point out that while, no, I'm not necessarily a chemist or a toxicologist, however, I have been through a training program offered by the laboratory to train me or certify me in this program, which is to identify or presumptively identify these materials to be a controlled substance.
Better?
What if you just said, no, I'm not?
You're correct. I'm a field identification drug officer.
Yeah, let the DA bring out what your qualifications are, like, I don't know.
Well, but the DAs will have already asked that question. He'll already get you qualified.
So you're talking about cross-examination.
Cross-examination.
As a defense attorney. So as a witness who's trying to qualify as an expert witness, it's your job at that point to bring out the point that, no, while I'm not a chemist, I can at that point add, unless an objection is raised by the defense attorney that while I'm not a chemist, I have been through a training program, a certification program for this. And this is my certification number.
Right. The two things. One is you're assuming and hoping that the prosecutor has brought that out and made that clear during his initial qualification of you as an expert witness. The second part is, even if he's done that, doesn't prevent me as a defense attorney from attacking that. And I would do that to call into question or raise some question. Understand, I'll be the first to tell you, as a defense attorney, I get some of the crummiest evidence and cases to work with that you can imagine. Because are they drugs? Well, yeah, they are. Were they on him? Yeah, they were. Did he stab her? Was there a witness? Whatever the case may be, it just, I assume I like to be abused because because somewhere along the line I went into defense work instead of prosecution because the win ratio compared to state is not good. So the point being is that finding ways to answer those questions when you're on being attacked, even though there's no real basis for it. Because what the defense attorney is trying to do at that point is make an issue where there really isn't an issue. And depending on your jurisdiction and whether he knows you or not, or whether he has something else to go beyond that, he's just trying to make something. If you respond hostilely towards that question or defensively, no, I'm not.
I was to say, because any good defense attorney would then, if you continued on and tried to say, but however, I've done this, they're going to stop you.
Yes
They're
or
going to
no.
cut you right
Tell
off.
them that.
Right.
Yeah,
Yes or no.
just this yes or no.
My qualifications as an expert witness in this particular field consisted of FIDO training at NFSTC that was funded on a national program from NIJ. In addition to which, I had X number of hours in the lab or handling the kits or number of years of experience or courses or training and things of that nature. You answer the question by not answering the question, quite honestly.
Yeah.
And yeah, he can object, but you're trying to answer his question. And as long as it doesn't come across defensive, then it works okay. If you just say, no, I'm not, it's absolutely a correct way to answer. It's not incorrect in any sense. Understand that some things you try and do, and having been on all three sides here, okay? I've been on the law enforcement side, because I've testified as a law enforcement officer. I've testified, I've prosecuted cases and used prosecution side, and I've done defense work side. Whatever answer you give is all part of a puzzle. It's not going to be the answer in itself. No matter what you tell, or no matter what your response is, somewhere down the road in closing arguments, he's going to turn it into whatever he wants it to make it anyhow. So if you start giving him, no, I'm not, closing argument's going to sound something like, well, you heard the so-called expert. The so-called expert admitted she wasn't a chemist or a toxicologist. And they just dressed her up to look like an expert because they just didn't have anybody. They didn't have anything. But she admitted on the stand, no, she was not a toxicologist or chemist. That's what the jury will hear at the end. And in contrast to that, if you start going down, okay, well, if you answer more in the expounded version, well, my qualifications are the training, NFSTC, NIJ, courtroom, lab, all this. He can't twist it anymore. Because for him to twist it, he'd have to repeat all those things again. Or the prosecutor could come up and say, the defense attorney tried to twist the lack of a PhD into an issue when it really wasn't. Because you heard them answer the questions. Now, with respect to FIDO, the other thing that I noticed in preparing this is that contamination. Contamination will always be an issue. How do you, if you have testing that is sensitive, and now even with in comparable fields with touch DNA type stuff, and with drugs especially, I mean, what percentage of money is now tainted by drugs?
All of it.
So did you go eat lunch before you handle this evidence and pay your bill? Did you go to the ATM and get money for tomorrow or count the money before you started handling the testing?
I could, because I put on gloves.
No. But did you touch the exterior of the gloves, put them on before you got them?
Yeah.
Did you handle the defendant's pockets or reach in his pockets to see what the object was during the search before it produced the drugs? That the drug may have been on your hands and not necessarily from the substance itself. So how do you start contamination, cross-contamination issues?
That's good, that's all trace stuff, I don't have to worry about that.
It may be traced, but it still falls in under your contamination.
What
And
did you
those-
outline the procedures that you were given in your training that suggested that no, we only open one case? Things that we do to prevent that or to minimize the possibility of contamination would include opening only one case at a time, cleaning the surface with a disposable decontamination procedure beforehand, that kind of thing. So you've outlined exactly what your procedures are, and that gives him maybe more information. You know, we're taught not to give more information than we're asked for, but at that point, they need you to do that so that they understand that you are aware that contamination is possible, and there are some things you can do to minimize that effect.
And also part of the screening tool is a control, which would indicate if you had a problem with your system or a problem with the testing kit if it was contaminated. And if you've done the control and you followed procedure, it would indicate it was negative, so you weren't dealing with a contamination issue at that point.
All good answers, all the best ways to approach it. Because what you'll need to do is point out the proactive measures that have been taken in putting this program in place, from your training to the kits that are constructed to the procedures that you follow, and expound on them during trial or during testimony to show that this is how the controls work. Not only do I know there wasn't contamination, I know there wasn't contamination because of these particular issues. Had there been contamination, I would have expected to see this result at this particular location, or this particular color turn out, or this particular result come about. And that will go true for third-party contamination as well. Chemical kit components. So here's the question. Who's going to answer?
You're looking at me.
Give me a hand.
Come on, Melissa, save us all.
We don't have a kit.
There you go. It could be any kit. We don't know what kit you're talking about. Wait, be specific.
Gentleman all the way in the back in the corner. Where are you from?
Cambridge,
Okay.
Massachusetts.
Yeah, no, we have a kit either.
That's a good-
Thank you for volunteering. Okay. So,
Lost state.
so here's the question. You're on the stand, you're testifying to the results of your examination of this kit. Officer, how do you know what chemicals and what components are inside that kit?
Really don't know.
Well, so how do you know they work?
They were given to me by the state lab.
Okay. And do they conduct any type of quality control?
My understanding is that it's certified by the state lab is what the test kit.
Your particular kit or the kit is a batch?
My particular kit.
So they tested the kit you used in this case before they gave it to you so you could use it in this case?
Yes.
When they tested it, does it expire? I mean, do you just use over and over again?
This is a hypothetical answer because we don't have these type
I
of
know.
kits.
I know, and you're doing
I
fine.
imagine
You're okay.
that The kits would have an expiration date that would probably be a year or two or something like that. Be refreshed every once in a while and certified.
Now, see, and I come from the old Beltox days. Just 2 drops of this, 3 drops of that. You know, put it in the dirty scale at the police station evidence room and hope it came out right. But the point being is knowing what that answer is going to be. That's going to be one of those stock answers. What's in this kit? How do you know it works? How do you know your kit works? What's the quality control that your state or your lab or your agency uses to make sure it hasn't expired? Things that will become clear as you go through the program and as it's more developed. Again, a lot of these are just designed to start getting you thinking along these lines of what type of things are you going to encounter, what type of things do you need to be prepared to answer for. Sometimes they won't ever come up. Other times they may come up every single time.
The possible question, I gotta share this because it's the funniest thing I'd heard. A defense attorney had asked this expert, "Isn't it possible?" And he kept going like that. And the expert finally said, he said, is it possible lawyers lie? And, I mean, it just totally, it stopped the it floored the lawyer at that point. But I think after a certain point, you know, you gotta stop and say, what, this is hypothetical, I'm testifying to facts in a case, you know, not hypothetical situations. If the defense attorney keeps going, you know, is it possible? Is it possible? Is it possible?
Well, and that seems to be, isn't it possible, seems to be one of the most widespread issues and questions. Well, how do I answer, isn't it possible?
Say, yes, it is possible, but in this case.
Thank you very much.
It's highly improbable.
That's what would, I don't mean to be rude, but that's what you would do. You would get cut off just like that,
You try
and
to
then you
focus
move on.
that one case. In this case, that's what how
Right.
I would turn it. If you ask, is it possible, I would say, well, in this case, contamination was not an issue because I did A, B, and C as I was trained. So I just keep putting it back on this case. I'm not gonna talk in general terms, that's beyond my level of expertise. I'm talking in this case, where I was trained.
I didn't want to cut you off. Go ahead,
No.
finish. I'm just-
No, I always, my response is it possible? Yes, but in this instance, it's highly improbable.
Well, there's a reasonableness too.
Right.
Contamination, yes, you know, contamination is possible in just about every situation. Yeah, sure. However, it's reasonable, you know, it's unreasonable to expect contamination occurred in this kit. It was sealed when I opened it up, I sealed it back again. I only took out these materials. I was wearing gloves, the procedures I've been taught, all the way down the line. And it comes down to, I think, the training that you received before you became an officer, how well you did the program, went through the program, identified the materials, and handled yourself when you're doing your kits so that your training is complete. And then you can answer the questions effectively.
Would you say, who would have thought a man would have had a baby?
Love that.
There is, believe it or not,
Wow, that must have been a really long question.
You can. I mean, you can certainly do that. But understand that as soon as you do that,
Then it'll get more hostile.
yes.
it can. Or it's like, okay. And then I go right back to where it is no. In closing argument, I'm going to be sitting, you saw the expert. One of the things the judge will tell you as part of the instructions, the jury instructions that read, you can judge and weigh the witness's demeanor that was presented. Now, did I have a wise acre about, you know, did the man have a baby? Well, what's that got to do with anything, ladies and gentlemen? Come on. We're here about a serious situation. You're talking about someone's life and someone's being free, and they want to make jokes. Certainly not professional. If it wasn't possible, just say no, it wasn't possible. Why make light of the situation? Now,
Maintain your composure.
you maintain your composure and maintain your professionalism. Nothing will get you dragged down faster than you abandon those two things. Sir?
I think that as these two gentlemen pointed out, this was a hypothetical, and in a real case, the person testifying would have testified on direct examination about, you know, what training they have, and that would have come through to the jury. And then as the defense attorney cross-examining, saying, isn't it possible? Of course, because it's a real case, the witness would say, well, you know, I've been trained in this, that, and the other thing. And at some point, you as the defense attorney, if you continue that tact of isn't it possible, you're going to lose the jury. Because they're going to think that you're some sort of an idiot, you know? You know, that you're, you know,
Most of them already do, so.
you know, this, you know, the ones that do go on and say, you know, isn't it possible, is it possible, and the jury starts to think, you know, that's enough, you know, we already know what's going on. So I think on a real case, it's not gonna fall the way you're talking. I think in a real case, it's gonna flow, and if you have a bad witness, you're gonna score your point, you're not gonna continue going, it's impossible, it's impossible.
There's a difference, and you're exactly right. There's going to be a limitation as to how far anybody can push it, whether it's a defense attorney or prosecutor. You can only push it so far before then you start going down the downside of the hill, and you start losing that credibility. But even as a defense attorney, I'm going to push that. I mean, I'll go to the top of the hill, and trust me, I've fallen down the other side of the hill plenty of times in the course of it as well. But I have to do that to a certain level. Part of it is your reaction. as well as an admission that it's possible. Because what I need from you in that particular instance is not, well, anything's possible. What I need is the possibility exists.
Reasonable doubt.
That's what I need to be able to go back during closing arguments. Because that's all I'm doing. All I'm doing is taking information from you to put in a bag, so when I go to closing arguments, I'm gonna start pulling things out of the bag. The expert said it was possible. The expert said this. The expert said that. The expert wasn't a chemist. The expert, whatever it is that I'm building. So I'm only taking bits and pieces. I may ask you 100 questions and only need 2 pieces of information from you. Sorry.
If I could, Greg, just, my point would be too, that there's not a defense attorney on this planet who's actually gonna try a case and hope to win it, that is not gonna have the FIDO manual from your state from discovery and know all these answers, and like you said, I think that's a good point, they're just looking to push buttons, so if you take the high road and maintain your composure, your fishing expedition ended up with nothing, and I think that's what a lot of it is about, it's just the answer as opposed to the composure type of.
Yeah, if you sound
If-
confident.
Exactly. If you take, if you take the manual that comes with the program and the procedures that have been honed and developed through the different states, and are aware of those and know them, and particularly know your state's application of the program, because you're right, the defense attorney is going to know that. I have more copies of Florida Department of Law Enforcement's DNA protocol than I know what to do with. Okay? Unfortunately, the state of Florida, or the state bar requires me to keep all my records for my clients from all the way from 15 years ago. So I have stacks of them in my garage. But it brings out another point. You have to be familiar with these materials because the defense attorney is going to know them as well. And they can get very minute, picky points, in terms of what's the chemical composition, what's the proportion, what's the error rate, at what point does it become ineffective? At what temperature and how long does the temperature have to reach a certain level before it becomes ineffective? So all those things have to come out. False positives. You're on the stand, somebody says, well, tell me about false positives. What is a false positive?
Again, even in that case, if I have the perfect opportunity to speak with my officer and completely prepare him for trial, I say, look, if there's a question like this, if this had nothing to do with your case, or if the defense attorney uses the P word, is it possible? You maintain your demeanor and you say, I'm here to testify about the facts in this case that I worked. And in this case, this is what happened. If you didn't have a false positive in this case, then.
Well, but see, here's the counter argument to that. You're holding yourself out as an expert witness. The court's going to recognize you as an expert witness. As an expert, you should be familiar with the terminology, the processes, the literature that's involved with that particular field that you're dealing with. If you're unwilling to, let's say we're doing this back and forth. You're the law enforcement officer, I ask you what the false positive is. In this particular case, there's no false positives. I really don't have an answer for that. Oh, so officer, your response is that you're only going to answer the questions you feel are relevant and not what are asked you. It becomes combative, and again, he gives me something by just not answering the question. And what I always tell people in preparing witnesses, listen to the question being asked. After the question's done, think about it a second. Let your mouth catch up with your brain. It gives you a chance to make sure that, one, if the prosecutor has an objection to it, he has time to stand up and object without you cutting him off or already answering the question prematurely. Two, it enables you to find the words that you're really trying to explain the answer to the question and that you understand the question. Third, if you don't understand the question, just ask for it to be rephrased or ask for it to be clarified because you're just not understanding what the person asking the question is trying to get at.
With regard to the FIDO program and the way we've implemented it in Louisiana, one of the things that we've always maintained is that if it does go to court, the police officer is not going to court to testify to his findings. He's going to have the backup of a laboratory analysis. And therefore, a false positive becomes moot, because had it been issued to us and it was a false positive and they said it's going to court, we tested, it's not positive, he's gonna drop the case. It's not gonna go forward. It doesn't mean that I don't need to work with the FIDO officer that turned that in because he gave me a result that was positive. That becomes a completely different issue, but at that point, in that instance, it didn't occur because it didn't get to court as a falsely positive result. So, I mean, yeah, you need to answer the question that false positives, yes, they are possible, and they have occurred with some known samples of materials that are similar to cocaine, as an example. However, if the cases in our program, again, if we get ambiguous results with the color tests, we're required to send them to the laboratory. If I just don't know the answer, I send that in because there's a possibility something's interfering with my test. And they're trained to do that. And that's part, again, I have to go back to the training. If you can train your officers well enough to anticipate the possibility of false positives or interfering compounds, then they're better armed to answer the questions when they get to court.
I agree, and I think it's the best way to produce it, the best way to go about it. And I think the FIDO program does a lot of that for you in terms of putting the packages together, the training together. The false positives is really just a matter of terminology and definitions. And it's really, you'll find it probably more with the inexperienced defense attorney trying to stab at something that he himself doesn't really understand. So
if you asked me to define, if you said, what are false positives, or can you give me examples of false positives of materials that mimic cocaine, then as a FIDO officer, if I've been properly trained, I would have to at that point say, well, there are compounds out there and some of them include lidocaine and procaine and stuff like that. Well, in the FIDO training that we provide, we tell them that there are compounds out there and list them and say they're similar to, but they're not controlled. They're related to cocaine. And that's how I've explained it to them. I'm hoping they remember that portion of it, that's where it comes out.
depending on how the question is really phrased. I mean, if I just come up and simply ask, can you explain what a false positive is? Then the easiest, most direct way to do that without getting into this tangle with what it is, how, whether it's in this case or not, is start with, well, by definition, a false positive is, and hammer out your pre-rehearsed, stocked false positive definition.
Which would be your attempt as a defense attorney to find out if I truly am an expert,
Precisely.
having had the training. And so you may be going for that. I can't decipher what you're going for on the stand. You're asking me something and I'm in the hot seat at that point. So my job isn't to try and figure out what you're trying to do. My job is to answer your question to the best of my ability. Because I don't know where you're going.
Right.
I don't want to know where you're going.
Police officers, unfortunately, are probably the most guilty of trying to guess where the defense attorney is going and try and cut them off, only to find out they weren't going there, and then inviting new issues to come up in the process. I caution people to try and guessing where the question, what the next question is going to be, because you may not know. Again, I've had experts, I've stood up and asked a couple questions and sat back down. And the expert sat doing, that's it? Yeah, that's it. Because 2 questions are all I needed. There was no, I mean, and again, leave it to the lawyers to do the strategy portion as to what's going where and how it's going to be presented, who's going to be attacked, who's not, and all, because they have all those things, they have their total case together. Your role is to provide that piece of the puzzle that pertains to the FIDO testing. Let's see. Again, coming back to the qualifications as the expert, again, and whether you're going to be qualified as an expert may make a difference on this. If you're going to be held out as an expert, then I could easily see, well, what other substance could result in these results? Is there anything other than the drug that's being charged that could produce a similar result? If you're going to be the expert, you need to know what those answers are and what those substances are. And again, it's a learning curve. It keeps on growing, and the list changes, you know, from time to time. A couple of the other issues that we found in here, as far as what would or would not be subject to some attack, is, well, this process is relatively new to your agency, isn't it? So we really don't know how reliable it is, because your agency hasn't had enough experience with this. So can you explain to jury how it's all of a sudden reliable in this particular case? Probably one of the easiest things that is subject to attack a little bit is the subjective nature. Imagine that for a moment, everybody's eyesight is going to be questioned at one time or another. What color were the test results? Because they're not measured in terms of a numerical scale or a quantifiable scale. They result in from different colored chemical reactions. So is blue different from aqua, which is different from fuchsia? Take your pick. I mean, who sees what color? And without having that kit immediately available to sit there and say, see, here's the color I had. Well, now we don't have anything to back it up beyond that, assuming it's just a presumptive issue at that point. Obviously, if you go back into the probative lab testing, then it becomes a different story. But how do you overcome that? How do you substantiate that? Another issue that, and we touched on it earlier, was the not being qualified to testify and requiring a more advanced degree or level of education. You're not a chemist. What are some of the quality assurance methods that are contained in the kits that you use? Knowing what they are, knowing how they apply, knowing where they fall within the parameters, knowing what your agency's protocol is and how that syncs up to work properly is going to be a question you want to be able to prepare to answer, because they will be asked. Especially for the first time that you go on individually, and the first time as an agency or as a state you start putting these online. The good news is, on this side of the fence, is that the defense bar is probably, in terms of a lot of forensic issues, 3 to 5 years behind the prosecution bar. I went to a national defense conference a number of years ago, and they were still talking about Photoshop as defense for child pornography cases. And that technology, and it was so old at that point, but that's where the defense bar is. The other thing is the defense bar doesn't take a proactive approach to a lot of things. What they do is, well, I'll wait till the case comes on my desk, then I'll read about what this FIDO is and what I have to know, then I'll get the manual through discovery, and then I'll make it up from there. So they're going to be on the same learning curve, but they'll actually be behind you because you've had the training and the hands-on experience where they haven't. See, I had a lot of challenges to work with. How do you know that the contents aren't defective? How do you know you're getting an accurate result? And into all the other ones. Let's see. The second from the bottom there, the inability to quantify the result or provide an error rate. Daubert, Fry, expert testimony, pretty much across the board requires some quantification of what you're talking about in terms of, well, how likely is this an error? How is this recorded improperly? Even know what an error rate by definition is. And a lot of people guess, so I would suggest, number one, don't guess. When you're here at the training or in your own personal venture, find out what a technical definition of error rate is. Again, if you're asked to define it, and then also how it would apply to your particular case and circumstances. That's my contact information. I normally, being a former cop, I tell everybody, if you need anything, call, shoot me an email, whatever. I'm more than glad to answer any questions I possibly can. I had a judge who always used to harass me because I was on the defense bar and I appeared in front of him quite a bit. And he was a Marine and I was in the Army, so he didn't care for that aspect of it either very much. So he used to be a police officer before he went to Marines and took the bench. He goes, "You've gone to the dark side now." Well, it took me a number of times in front of him before I finally came up with an answer that finally got the question from stop being taunted out there. Judge, I didn't know justice had a dark side. Never asked again. But it's true. So I don't hide things, well, unless you're the prosecutor on the other side of my case, I don't hide things from you. I'll answer any questions that you have or want answered, and whatever I can do to help you guys out. Appreciate it. Appreciate you having me. You've been really great, and we are done early.
They may have questions.
That's true. But see, now I said it's early and it's 4 o'clock, so do you have any questions? Any issues, any thoughts, any concerns, anything that I can? All right.